Now, good afternoon, everybody, and good morning, depending on where you are. You're all very welcome to this final session, panel three of the sessions this afternoon. And this is, I think, a particularly interesting session because we've got seven speakers who are going to address in 5 minutes each some of the most significant issues affecting arbitration and international arbitration right now. So it's going to be an enormous challenge to speakers to keep their presentations to 5 minutes. And my job, apparently it's the only job I have, which is to ensure that people stay to 5 minutes. That means there won't be a huge amount of time for introducing each of the speakers. Each speaker has a short and, if I may say, very understated introduction for themselves in the brochure. And I might just touch on some of that while I'm introducing each speaker as they just as they start. Unfortunately, the time also doesn't permit me to respond to the man who posed earlier as the Attorney General in the keynote speech this afternoon. I was able, in the meantime, to make a call to the Attorney General's office to report that some lunatic appeared to have taken over the office of the Attorney General for the purpose of that keynote address. And I can assure you that they have all of that under control, and the real attorney will be restored to his position very shortly if he hasn't already been done by now. So without any more introductions, I want to introduce our first speaker. That's Philippa Charles from Stewart's London, who you will all know, who's a regular speaker at this conference. She's introduced, as I say, in a very understated way in the brochure. She obviously has enormous experience in the area of international arbitration in a whole range of fields. And Philippa is going to talk to us in this quick fire round on pitfalls and unexpected challenges in virtual hearings, both for counsel and for arbitrators. Philippa, you're very welcome.
Well, thank you very much, Judge. I'm reminded at the start of this quick fire session of a rather interesting comment I heard earlier in the year, and I can't remember whether it was you, Judge, or Michael Collins, who said that one of the great things about Dublin was that we'll speak so quickly as Irish people that the transcribers are the best in the world at picking us up at speed. So you'll forgive me if I go a little quicker than I would normally in an arbitral setting. It's a great pleasure to be with you all this afternoon. I only wish it could be in person. As Judge Barnable has said, I'm starting on the pitfalls of virtual arbitration for all participants. I've had the great privilege of doing 6 virtual hearings, some as counsel, some as arbitrator, since June. And so I think I have a reasonable panel of experience from which to draw my comments. I have 6 topics, so I'm going to see if I can get through them in 5 minutes or less, and obviously happy to take questions at the end. First problem, rogue witnesses. It's a lot harder to spot a rogue witness, it seems to me, and I know Charlie Carr takes the opposite view, but you don't know that someone's looking at a random document that's been prepared by his solicitors until halfway through his cross-examination, when it becomes apparent that he's checking something off screen. And you ask the question what he's looking at, and he waves it at you. Similarly, there are other witnesses who will turn up with documents of their own that they'd like to wave at you down the camera. And as arbitrator, that's quite a challenge to deal with. So I think there's a lot more work to be done about controlling and establishing parameters for the witnesses, because I think in a room where everyone is present, you can have a paralegal at the door to whip things out of people's hands before they sit down at the witness table. I think it's much harder to do when they're 4 time zones away in their bedroom giving evidence. So I think there's a real issue with the assessment and the management of witness evidence in these remote scenarios. I think there are also occasionally rogue arbitrators, in the sense of arbitrators who are not fully conversant with the tech before the hearing gets going. Now, many of the arbitrators are brilliant with it, but I think this, coupled with what I'm going to talk about next, which is the sort of mental burden of the virtual hearing, I think it can cause problems both with hearing preparation and in terms of simply assimilating what's going on in front of you. So my third topic is sort of broadly Zoom fatigue and other brain challenges. And there's a very interesting series of articles which Cortex Capital has published, which I commend to you all, about the mental overload of trying to work off maybe 5 screens in order to take in the information from the bundle, from the video conference, and so on. And the analysis that they've done is even to take into account and then block out of your mind everyone's backdrop in a virtual hearing scenario takes up so much brain capacity that it reduces your ability to take in the information that's being fed to you by a percentage, which is quite alarming. And obviously in a hearing room environment where you're all together, you can see everybody and they can see you. And there's a sort of commonality of environment, which I think is reassuring, which you simply don't have in the virtual sphere. And I think there's a real risk of us overestimating our ability to process all of that visual input efficiently and effectively. There are massive transcript issues. Over-speaking is always a problem in cross-examination, but it's much harder to control as an arbitrator when it's going on between 2 remotely located witnesses and counsel. I have certainly received transcripts after the event that were essentially unusable in portions because there was so much over-speaking between the witness and the cross-examiner that it meant that the transcript was effectively useless. Now, that's partly a challenge for the transcribers from a technical perspective, but it is also a challenge for the advocates and for the arbitrators to spot when that's happening and to try and control it. And with live note, you can't always be sure whether the overspeaking is correctable or not when the audio comes back. And you have one chance to get your transcript down, and so that is something that is a real issue. Time zone issues, massive problem. I had a hearing recently where I have a co-arbitrator on the west coast of the US and a co-arbitrator in Hong Kong, and the parties are in Seoul. And so in order to facilitate a 1-hour case management conference, we had to do it at 6 in the morning my time, because it was the only time we could facilitate everybody else within a sort of reasonable waking day. And obviously when it comes to fixing the hearing for that case, it's going to be a real challenge to find enough days to do it. And I think that's causing problems with hearing listing as well, because you're effectively having to list now in anticipation of maybe needing twice as much time to get through the evidence, because you're only going to have maybe a 3-hour sitting day. So I think it will reduce arbitral capacity to some extent if we continue to have fully remote hearings with sort of vastly diverse time zones involved. And then finally, on e-bundles and online case management issues, I think my experience so far is that the really joined up products, I know they look expensive from the practitioner side and from the client side. They are so worth it. I can't begin to tell you how much more difficult it is to manage a virtual hearing with an unjoined up approach to the video conferencing, the transcribing, and the e-bundle. It is far, far less efficient. So the cost is definitely worth it in my view. And I'm not being paid by Opus 2 to say that. There are data protection and security issues, which we probably don't have time to get into, but which are a real point of concern for me, especially in this sort of unintegrated universe where you may have arbitrators carrying arbitral bundles around on a USB. I think they are real risk issues for us going forward. And I think there's a real need for tribunals, parties, everybody properly to grapple with GDPR and the other requirements in relation to data security and data protection, because that is not going away, even if and when the UK finally walks off out of the EU. UK-based arbitrators are not going to be able to ignore the existence of the GDPR and other similar legislation elsewhere. And on that note, I will yield the floor back to Judge Barnacle.
Brilliant. Thanks, Philippa. Good timing. Thank you very much for that. We now move on to our second speaker. That's Ravi Aswani from 36 Stone Chambers in London. You'll see Ravi's description in the brochure, somebody, again, of immense experience, and he's going to share that experience with us by telling us how aspiring and junior international arbitration practitioners can advance their careers at during the COVID pandemic period. Ravi.
Thank you very much, Judge. Thank you all at Arbitration Ireland for the opportunity to speak today. My topic will, I hope, be of interest not only to those already practicing arbitration in one way or another, but also to any students who may be with us today. What I've found sometimes gets insufficient attention in topical discussions is the effect of COVID-19 on the career development of aspiring and junior practitioners. So I have 4 minutes and I'm going to give you 4 tips to think about. Tip 1. Reproduce the work water cooler moments. What do I mean by that? Well, speaking for myself, what I have missed in particular in working from home since March is really the human interaction, the spontaneous discussions we have with our colleagues at the water cooler, in the kitchen, etc., around the office. And one of the things I found over the years about international arbitration in particular is the very genuine sense of fraternity, both across the generations and across different organizations. So I always tell people, don't neglect the internal aspects of career and business development. Senior practitioners are, in my experience, almost always interested in the career development of their junior colleagues, and that's particularly the case in these difficult times when they will also have well-being concerns. Still, I think it's all too easy for this cross-generational interaction and communication to fall off the radar a bit when everyone is so busy working remotely. So how might you remedy this? Well, I think this is quite straightforward, actually. Try reaching out to your senior colleagues. Ask them if you can have a one-to-one remotely over a cup of coffee. Yes, of course, everyone's busy and may not be able to do it straight away, but the prospects of them being willing and able to spare some time once free of urgent commitments are, I would say, good, because they will care and they'll be interested. Tip 2, take advantage of the democratization that COVID has brought. What I've seen in attending conferences remotely this year has been the leveling of the playing field in terms of attendees. Many more attendees from developing jurisdictions, many more attendees who are junior. I think all of us have a responsibility to ensure that the embrace of virtual platforms continues, and that even when in-person conferencing becomes a possibility again, hybrid offerings continue to be provided. How might you take advantage of this? 1, ask a perceptive question. I've seen a much broader mix of questions in virtual conferences from different people compared to what sometimes happens at in-person conferences, which is the same old faces asking the same questions at every conference. Not something that ever happens at Dublin International Arbitration Day, I hasten to add. 2, don't neglect virtual networking. I appreciate it can sometimes be a turn-off and there's a temptation to log off immediately after substantive sessions, but remember, everyone's on a screen and has a video pane that's the same size. It's therefore much harder for the usual suspects to dominate virtual networking, as can occasionally happen in person. And 3, follow up in an appropriate manner. As speakers, it's always a little difficult to get a sense of how a presentation is going down virtually. It's very difficult to establish that audience rapport. If someone reaches out to you as a speaker, either in virtual networking or by subsequent email, not only is there an inevitable ego stoking, but remember the sense of fraternity I mentioned. People want to help junior practitioners and are always keen to do so when they can. Tip 3, make yourself known to arbitration organizations. All the major arbitration organizations, whether institutions administering arbitration or not, have young groups which are always free to join. But don't just join the mailing list. Email the young group coordinators asking, how can you help? You never know when you might be called upon. It'll be easier things to start off with, helping out at events, but you never know where it might lead in time. And that neatly brings me on to my 4th and final tip. Be prepared to be in it for the long haul. John Beechey, former president of the ICC Court of Arbitration, has a wonderful tongue-in-cheek complaint that the Vismut engenders legitimate expectations in very junior practitioners that they'll be lead counsel in a $10 million commercial arbitration on day 1 of practice. That's not going to happen. You've got to be in it for the long haul and be prepared to put the hard work in. Well, I think there's plenty more I could say, but I hope this quickfire presentation has got some creative juices flowing. Thank you.
Thanks very much, Ravi, and thanks very much for keeping to your time with those four critical points. And there may be questions arising out of those if we have time at the end. Just a reminder to everybody, the questions and answer box can be used. And if we have time at the end of this session, I'll come to some of those questions. Now, our third speaker in this quickfire round is Louis Flannery, QC, somebody you'll all know, and now flying under the flag of Mishcon de Rea. A very experienced author, as you've seen. We all miss many things about the real life physical arbitration day here in Dublin. But one of the things I think a number of us miss right up the top of the list is dinner with Louis. Now, Louis, what can you do for us? You're muted, I think, Louis. I should have said you're going to talk to us about the UK Supreme Court's decision in Enka and Chubb. I think you might be muted.
I am. Let me repeat Ravi's thanks to you and to Rose and to DIAC for this opportunity. My first, I hasten to add, since lockdown in March. And if anybody sees the hair dye running down the sides of my face, please raise a hand and let me know. I'll try and keep my speech a lot shorter than Giuliani's yesterday. And I'm not going to talk about any unfair decisions. I'm going to talk about Enka and Chubb. For those of you who don't need to get out a little bit more and know something about it, it is the Supreme Court's decision in a case that effectively turned on the law applicable to an arbitration agreement when the matrix contract pointed one way, brackets, Russian law, close brackets, and the seat of the arbitration, being England, pointed another way. The Court of Appeal, led by Lord Justice Popplewell, had said, time to draw a line in the sand. When the seat is chosen, the arbitration agreement will be subject to the law of the seat, unless there's a clear indication to the contrary, whatever the matrix law says. I was among a number of people who thought, well, no, I'm really sorry, that's just not right. I know that there are advocates of that approach. It certainly was not consistent with the majority of previous decisions at first and appellate level, at least in the English courts. Unsurprisingly, permission to appeal was given, and the Supremes reigned supreme last month. But what a wonderfully split court. 3 judges saying Court of Appeal got it wrong. No express applicable law to the matrix contract, therefore we're free to decide. And they went with English law on the basis of a quasi-Rome regulation approach. And I'll come back to it. But effectively, they landed on English law applying to the arbitration agreement, therefore an anti-suit injunction could be granted. The minority, and the majority, by the way, was Lords Leggett, Hamlin, and I'll be correct if I'm wrong, Sales. No, Sales was in a minority with Burroughs, but I can't remember who the third law lord was with the majority. I'll come back to it. But he agreed with basically Nick Hamlin and George Leggett, who said it is the law of the seat. Now, what they did was they looked at the matrix contract. The matrix contract didn't say Russian law on its face, but it had 120 or so instances in it where it was obviously referring to Russian law. The project was in Russia, the parties are Russian. It was quite obvious that it was a Russian contract, except, sorry, one party, being the Turkish contractor, was not Russian, but everything else pointed to Russia. However, they said, no, that's not enough. That doesn't get you express choice. That doesn't get you implied choice under the Rome regulation. And I'm not talking about Rome regulation applying to the arbitration agreement. I'm talking about it applying to the matrix contract. They then said it's closest connection, but if it's closest connection, we can put aside everything else pointing to Russia and we can look at the seat. So they went for the seat. They strained, I think, the reasoning a little, but the minority, as in Lords Burroughs and Sales, said no, everything pointed to Russian law as an implied choice, and it follows by the principle that the majority accepted that if it's Russian law for the matrix contract, it must be Russian law for the arbitration agreement. And if they'd been right, it would have been thrown back at the commercial court to decide whether the proceedings in Russia, which had been brought arguably in breach, and which were the subject of the suit, were right or wrong. I think that by a whisker, the minority was right, but the majority view at least knocked out the Court of Appeal's basic premise, which was law applicable to the matrix contract. The law of the seat governs the arbitration agreement. I think that was wrong. I've got 20 seconds left. I can only sum up by saying that I was chuffed to bits to be cited by both the majority and the minority. Thank you very much.
Congratulations, Louis, and well done for keeping within your time. Our fourth speaker is Claire Ambrose, and Claire is a full-time arbitrator with 20 Essex in London, a former colleague of mine in that chambers, appointed a Deputy High Court Judge in England and Wales in 2018. And Claire is going to talk to us about particular issues concerning conflict of interests. Claire, you're very welcome.
Thank you, Judge. I'm talking about conflicts, and it's topical here in London because we're about to get a Supreme Court decision. We've been told today that it's coming out next Friday, so it's just a little bit late for us. And this one's called Chubb and Halliburton. I'm talking about it because it's not an English issue. Every system expects impartiality as a basic standard in arbitration. And my topic is looking at how impartiality works alongside another basic standard, which is confidentiality in arbitration. It's a sensitive topic, and I'm going to use Chubb as a case study. It's an insurance case, so it may be relevant in the context of COVID, but it involved a more obviously man-made disaster, the Deepwater Horizon explosion. And there were several big insurers on the line. Arbitrator X, who was involved, was appointed as chair, and his name remains anonymous, but we know he's a very experienced senior London Silk. And over the years, he had been appointed several times by one of these insurers. He was what they call a frequent flyer. And when he was appointed, he disclosed those appointments. Sometime later, he got appointed in another couple of Deepwater references, and he disclosed his earlier appointment in those cases, but didn't go back to the first parties to disclose. The rest is history. He finds himself being challenged. He's not taking part, but he's being challenged, and he was criticised for failing to disclose in the Court of Appeal. And now part of the dispute is as to the consequence of non-disclosure, not just whether he should have disclosed. Philippa had 6 points, Ravi had 4. I'm going to raise 5 points, and the practical, number one, a practical one, an alarm bell of watch your back. We could all fall into the trap that he fell into. There is a tendency to look carefully on appointment at conflicts and take the time then, but then relax, and that's not the right approach. It's ongoing, the burden. Point two, look at the difficult question of judgment. Beyond the IBA rules, how far do you go? Certain institutions simply will not appoint if there is a disclosure, and it can be a difficult balance between caution and common sense, and I'm not offering an answer. Point three is, how do you maintain confidentiality and also make sure that your disclosure is sufficient? How much detail do you have to give of your other related appointments? And in related cases, the disclosure may be quite sensitive. The mere fact that arbitration has started or that certain firm is instructed is going to be sensitive. So it can be a fine balance. My fourth point is the question of principle that we're waiting for guidance on. What's the right test for bias? Is it the same as in litigation? And again, confidentiality comes back in, because if this was litigation, you would have a public record of when the judge had decided cases involving the other side, and importantly, what had been decided. And in addition, you'd have a wider ability to appeal than you would in arbitration. And so should there be a stricter test in arbitration? My fifth last point is whether it's a good thing or a bad thing having an arbitrator who's involved in several related references. It can make for consistency and make things more efficient than having several multiple conflicting references. But a lot of institutions don't embrace the idea of a common arbitrator, even though the ICC and LCIA have recently relaxed the rules on concurrent hearings. It's not the preference. And the disadvantage of having the same arbitrator appointed in related references is to make sure there isn't an asymmetry of information, and that could be unfair. If you've got one X in two references, everybody needs to know what's going on, not just people on one side of the fence. So again, it comes back to confidentiality in deciding, do you share more information to have a level playing field, or do you protect the confidentiality of the information in each reference? And again, I'm not going to offer a nice clean answer on that. And on that, I will wrap up.
Thanks very much, Claire. Thanks for sharing your enormous experience with us. And in those 5 bullet points, I think you've given excellent advice to people. Our fifth speaker is our own Susan Ahern, a barrister here in the Law Library in Dublin, and also international arbitrator attached to 33 Bedford Row Chambers in London. She's an arbitrator at the Court of Arbitration for Sport and a member of the ICSID conciliator panel. And Susan has a wealth of experience in sport law or sports law, depending on what side of the Atlantic you're on. And she's going to talk to us about arbitration through the prism of sport. And could I just ask everybody to mute their microphones if they're not Susan now? Thanks. Susan.
Thank you very much, Judge, and good afternoon to everybody. And I'm delighted to be in such esteemed company this afternoon. So sport, as you probably know, is one of my favourite topics, but sport has also always had its own way of doing things, and indeed individual sports more so again. But sport has evolved over time, and the type and significance of the disputes also have evolved exponentially. So recourse to arbitration as an external dispute option for sport generally coincided with most sports membership of the Olympic movement, where the Court of Arbitration for Sport is the ultimate arbiter. And the position of the CAS has certainly increased exponentially since the World Anti-Doping Code made it the final court of resort back in 2003. So I'm going to look really at how CAS decisions are challenged. They are final and binding, and they are only appealable to the Swiss Federal Tribunal on limited grounds. I'm just going to look at 2 favourite approaches, though there are many. And the first is to challenge actually the independence of the CAS itself. Its current formation has certainly been challenged on innumerable times before the Swiss Federal Tribunal in successive cases since 2004. But never successfully. And indeed, that tribunal has found that the CAS awards are true awards, and they are equivalent to the judgments of state courts. And so while the independence itself has not been overturned, certainly there has been a chipping away at the edges. And one particular case, which one brings to mind, is Pechstein and Switzerland. Claudia Pechstein was a decorated Olympic speed skater. She was given a 2-year ban for doping in 2009 by the International Skating Union. She challenged that decision before the CAS and lost. She continued on to challenge it before the Swiss Federal Tribunal and again was unsuccessful. And she was challenging on independence grounds and certain other procedural grounds against the CAS. But her determination brought her, like a growing number of athletes, to the European Court of Human Rights, where again she challenged the decision on a number of grounds, including her right to a public hearing. So the court had to look at first whether or not CAS was an independent tribunal pursuant to satisfy Article 6.1. It decided that it did. So with that independence established and certain other procedures, it went on to say that in actual fact that Ms. Pechstein had expressly requested a public hearing, and that request had been refused, and that was not justifiable. So they found that a public hearing ought to have been held by CAS. And so the position now with regard to CAS is effectively set out in their rules, which is that the default position is that hearings will not be in public unless the parties otherwise agree. And most cases are not public. The most high profile one in recent times being the WADA and Sun Yang case, which received a lot of profile. The second avenue of challenge to CAS awards is around the validity of mandatory arbitration clauses for organised sport. Because athletes are not directly connected as members to their national and international federations, contractual clauses either in their employment contracts or through the rules by way of reference are the means by which the arbitration provisions govern them. So athletes have to choose, do I want to participate in the sport under these rules or not at all? And the underlying aim of that was to ensure effectively the same sanctioning regime, a level playing field, and the ousting of the jurisdiction of the national courts. And so certainly the Swiss Federal Tribunal very much examines arbitration agreements in sporting contexts in a benevolent way with a degree of goodwill. And it was looked at in the Pechstein case as well by the European Court. And they asked the question whether or not in submitting to this arbitration clause, whether the athlete had waived her guarantees as provided in Article 6.1. And they found that because she had not freely given her consent, and that she had not waived those rights. So it was considered that that essentially was the end of the matter through the determination of Pechstein and as followed up in the decision of the German Federal Tribunal in BGH earlier this year. However, there's a twist in the tale, and a recent decision in the last month of the District Court of Frankfurt has again challenged the validity of mandatory arbitration clauses by in a case which involved two beach volleyball players and the German Beach Volleyball Federation. So as yet, it's unclear how the court came to the conclusion that that particular arbitration clause was invalid. The press release doesn't tell us very much, and we await the decision. But what is clear is that the challenges to the independence of CAS are not really a particularly successful route, but more and more athletes are going to the European Court of Human Rights, including Castor Semenya, who's, I think, next on the block. And I'll hand over to Judge Barnacle again. Thank you very much.
Susan, thanks very much. We await with interest the developments in the beach volleyball case. I'm sure we'll be queuing up to see the outcome of that case. Thank you very much, and thanks for keeping to your time. Our sixth speaker is our own Patrick Leonard, Senior Counsel, practicing at the Irish Bar with a particular interest in commercial and chancery litigation and in arbitration, former chair of the Bar Council's Arbitration Committee, and somebody who's been spearheading the Ireland for Law project and the project to promote Ireland as a centre for global dispute resolution, somebody who's done an enormous amount of work in that area. And Patrick is going to talk to us about a particular issue, that's arbitration under derivative contracts in Dublin. Patrick. Patrick may either have dropped out or maybe on mute. So I will just try this again.
Can you hear me there?
Yes, perfectly. Perfectly. Great. Go ahead, Patrick.
Sorry about that. So I'm talking about something that is objectively very boring, and the only reason which we might be interested in it is that it has a potential for work for everyone in the area. And that's the concept of derivative contracts in Dublin and why they might be arbitrated here. Just to give you an overall picture, up to recent years, 90% of the world's derivative contracts have been subject to the law of England and Wales or New York. And those derivative contracts, it's really quite astonishing volume. You'll all know that derivative contracts, it's a way in which financial counterparties can mitigate risk by dealing with other financial counterparties. As I say, the volumes are absolutely enormous. In 2018, there was over 735 trillion in value of derivative contracts in the European Union. So why am I talking to you about that? Well, the reason for that is that in 2018, ISDA, which is the world's leading organization for producing standard form derivative contracts, introduced options for Irish law and French law. And the reason they did that was in order to give financial institutions and other people in Europe an option of having an EU contract for their derivatives contracts. And there's lots of different reasons why you might want to have that. There is 6 weeks out now from the end of the transition period, no clarity on the enforcement of judgments of UK judgments and how that's going to work out in Europe. And there are also what one might call regulatory capital reasons, where under European financial services law, there's a good reason why you would have a member state law. So I'm here to talk to you a little bit about Irish law contracts. Obviously, Irish law provides the certainty of the common law system, and UK authorities, of which there are many in derivatives contracts, are regularly cited in the Irish courts. We're fully within the EU sphere. Traditionally, derivatives contracts were brought to court, but in recent years, perhaps the last 5 or 10 years, there's been an interest in using arbitration for financial services contracts. And that's particularly so in relation to derivatives contracts. And there's some very good reasons for that. These are obviously highly specialized contracts. And as we all know, when you have an arbitration clause, the parties can choose an arbitrator who has a specialization in the particular field. So derivatives contracts and disputes which arrive under them are particularly suitable to resolution by way of arbitration. Under the standard form, the standard form ISDA contract using Irish law, the parties have got an option to use the LCIA rules. So the standard form ISDA contract for derivatives, although normally it goes to court, and that would be the courts obviously here in Dublin, there is an option for the parties to use the LCIA rules with a Dublin seat and Irish law. One of the factors which I think people sometimes overlook in the context of disputes with financial services is enforceability. And now that we have at least, if I could say, potentially issues in relation to the enforceability of judgments between the United Kingdom and the respective states of the European Union, arbitration offers a very obvious benefit to parties in that an arbitration award is obviously enforceable under the New York Convention. I think that gives rise to somewhat over 160 countries. In terms of how much has arbitration been used in relation to derivative contracts over the last couple of years, well, I understand from a little bit of research in this that they are more often used in the Asia-Pacific region than in Europe. And it's thought that one of the reasons for that is that there are different regulators with different national laws in the Asia-Pacific region, and they like to then have consistency in using arbitration in Singapore. So obviously going forward, we're a period of uncertainty. Irish law financial contracts subject to EU law have the benefits of being part of the member state law, part of the regulatory system which applies to all financial services law in Ireland. The reason I'm talking to you about it, of course, is because of the introduction of the LCIA and rules and Dublin seat standard form contracts. I think generally one of the difficulties in persuading people to move outside England and Wales is that a lot of the standard form contracts provide for London courts and London jurisdiction. This is now a standard form contract which provides for dispute resolution in Dublin. And I hope that perhaps if we look back in 3 or 4 years' time or 5 years' time, we will see the growth of this particular type of arbitration here in Dublin. I just want to say one final thing in relation to what Philip has said. I find sometimes with having all the screens on, sometimes it's a good idea to turn the screen off if you're not talking. I often think if you're in court, you're not always looking at the judge and the other counsel. Sometimes you're looking at your papers. That's perhaps one way to stop the fatigue of screens. Thanks very much for listening to that topic, and I hope to see you all in the social event.
Thanks very much. Thanks very much, Pat. And I'm going to move finally on to our last speaker, Mark Cantor, formerly of Milbank, Tweed, Hadley and Wicklow. Patrick, you might turn your microphone off there. I think it may be still on, getting some feedback. Yeah. Okay, I seem to be better. And Mark's going to talk to us about something that's extremely topical, what a new administration in the United States will mean for international arbitration in the US. And Mark, you're extremely welcome to the 8th annual Dublin International Arbitration Day, and it's great to have you here.
Well, thank you, David, and thanks to Arbitration Ireland and the Dublin community for putting on yet another excellent conference. What a new administration will mean for international arbitration in the United States? The short answer is not much new. As I'm sure most of you who followed American public policy issues appreciate, the controversial hot seat public policy issues relating to arbitration in the United States involve proposals to limit or prohibit pre-dispute mandatory arbitration agreements relating to consumer arbitration, employment and civil rights arbitration, and class actions. There is some, but not very much, overlap with international arbitration in that area. The prospects, the appetite for technical reform to the Federal Arbitration Act are non-existent in political circles. And that's because the possible proponents of technical reform to the FAA are very concerned that moving forward with efforts to change the Federal Arbitration Act would be an open invitation to proponents of limiting arbitration in the areas I just mentioned to invade the legislative process and take it over and move to alter the Federal Arbitration Act to address those issues. So there's really no prospect for arbitration-related broad legislative activity in the United States. Now, major legislative activity in general relating to the United States for arbitration is highly unlikely in any event because the US Congress is so divided. And that is true regardless of who wins the 2 open seat runoff elections for the US Senate in Georgia in January. US political parties, Republican and Democrat, are broad parties with a number of factions inside them. And regardless of which party ends up in control of the Senate, they would be unable to muster a majority for one side or the other. And that is particularly true because absent control of the Senate by one of those parties in a very significant manner, there is no meaningful prospect to alter filibuster rules. That means you're going to need 60 votes for any major substantive legislation in the US Senate, and it simply won't be there. If there was any prospect of legislative movement in the US, in the Congress, it would be for either narrow subject area limitations, for example, restrictions on arbitration with respect to nursing home patients or with respect to workplace harassment, or it would be appended to must-pass legislation dealing with the financial crisis or the budget. However, that too is highly unlikely, again, because there just simply isn't a sufficient set of votes to push through in either of those 2 areas. What about administrative regulation? That is the approach the Obama administration took when it lost control of one of the 2 houses of Congress and no longer could push through legislation. In 2018, the US Supreme Court dramatically restricted the ability to move forward with administrative unilateral regulation restricting arbitration in the Epic Systems versus Lewis case. In essence, what that decision said is administrative agencies cannot rely on general pre-existing regulatory authority under legislation to limit arbitration policy of the Arbitration Act. You have to find specific authority aimed at restricting arbitration in legislation, and that really doesn't exist in most places. What about the ability of the administration to find relating to arbitration. Well, the Obama administration scoured the regulatory find, and the courts generally pushed back strongly against that effort throughout 2019 and 2020 after the epic system. The American government is, of course, the judiciary. The replacement of Ruth Bader Ginsburg, Tony Barrett, will not signal any meaningful change in the pro-arbitration jurisprudence of the U.S. Supreme Court. Justice Ginsburg was a proponent of restricting arbitration, but candidly, she was in those cases. Tony Barrett, which is unlikely, she would still remain in dissent. We will learn Tony Barrett's attitude towards arbitration for the first time on December 8th, when the case before the U.S. Supreme Court. Tony Barrett limited in the Court of Appeal cases in her 3 years on the Court of Appeal. Now, that's about all I can say in 5 minutes, but if you care to have an interest in any of these subjects, feel free to ask during the Q&A.
Thanks very much. The bad news, Mark, is that we've run out of time for the Q&A. So there is one question that Pierre-Yves raised, and perhaps Louis could address it during the social session at the end that immediately follows the conclusion of this session. Thank you very much, Mark, for that.
I've already done it, David.
Oh, you have? Brilliant. Fantastic. And just to wrap up this session, I think we all agree that each of the topics mentioned by the 7 speakers would justify a conference seminar, a conference in itself. I think our speakers have done a wonderful job to keep within the allotted time. Fantastically well done. I don't think I've ever been at or chaired a conference where beach volleyball, derivative contracts, and Rudy Giuliani's hair dye have featured in the same session. So that's certainly a first for me. And thank you very much to all of our panelists, and thank you to Arbitration Ireland, to ICSID, and to all the sponsors. Thanks very much.
Thank you, Judge Barnable, for chairing that session. Thank you also to Pierre-Yves for chairing the previous session, and to Nicola for the first session. It falls to me to conclude this conference, unique conference, and uniquely successful also, but we, without in any way undermining it, we really hope it is unique, that we don't repeat the trick in November 2021. We hope to see you all in Dublin in November 2021, when Visit will not be the drink in my hand at 5:30. Can I thank our sponsors, Cornerstone? Thanks to Ronnie Barnes for addressing us in panel 1. Thank you to Gwen Malone. Thank you for all the sponsors who are listed in the brochure, who always support us year in, year out. Thank you particularly to Gwen Malone, and of course to Rose Fisher for all that she has done to enable this. We're off to the social part of the evening on Zoom now. Thank you to Meg Kinnear and ICSID's WebEx platform, Cugger, who will be entertaining us in the Zoom platform, perhaps are too much for WebEx. So thank you, Meg. Thank you, ICSID. And thank you, everybody. Have a good night. Join us on Zoom for Cugger and traditional Irish music. When you see me at 6 o'clock, I think I will have a pint of Guinness in my hand. Good luck, everybody.